All rise, we would away. The International Criminal Court is now in session. Lord John to Court Panel International at overhead. Please be seated. We as well.
Good morning, everyone. Mr. Court Officer, kindly call the case, please.
Good morning, Mr. President. Good morning, Your Honours. This is the second situation in the Central African Republic in the case of the prosecutor versus Maxim Geoffroy Eli Mokom Gawaka. Case reference ICC 0114-0122. And for the record, we are in open session.
Thank you very much. Good morning again. I welcome everyone, parties, the suspect, Mr. Mokom, good morning, participants, the audience here and connected remotely. Now, I would like to ask the request parties and participants to introduce themselves. Mr. Prosecutor, please.
Merci, Monsieur le Président.
Thank you, Mr. President. Thank you, Your Honours. The Office of the Prosecutor is represented today by myself, Niang Mandai, Deputy Prosecutor, and with me, Senior Trial Lawyer Leonie Van Braun, Madame Colin Gilg, and behind me, our case manager, Madame Nera Mandavia, and trial lawyer Marie-Jeanne Sardaki, Matthew Kosi, Sandra Scooters, and Mr. Lucio Garcia. I avail myself of this opportunity to say good morning to the defense and the legal representatives of victims, and I'm happy to see faces that I am familiar with. Thank you. Thank you very much, sir.
Will you please introduce yourself and your team?
Merci, Monsieur le Président. Bonjour, Monsieur le Président.
Your Honours, good morning, Mr. President. Good morning, Your Honours. My name is Philippe La Rochelle of the Quebec Bar in Montreal. Today, I'm here with Mr. Mokom, who is behind us, and with me on the defense bench to my right, Kate Gibson, Khalin, sorry if I mispronounce her name, Julien Martin, Camille Diver, and Cécile Lecol. We are here on behalf of Mr. Mokom, and I take advantage of this opportunity to greet the chamber and also my colleagues of the Office of the Prosecutor. Thank you, Mr. President.
Thank you very much. Legal representative of victims, will you kindly introduce yourself? Good morning, madam.
Bonjour, Monsieur le Président.
Good morning, Mr. President. Good morning, Your Honours. We represent the team of common representatives of victims made up of Madame Marie-Edith Lawson-Duzima, Dangabo Moussa, and we have our legal assistant, who is Evelyn Ombeni, and I would also like to greet the prosecutor and his team as well. Thank you.
Good morning, madam. Thank you very much. So now the hearing is open. This is a hearing for the confirmation of charges in the case of Mr. Mokom. At this stage of the pre-trial proceedings, the prosecution is alleging that Mr. Mokom is responsible for certain crimes that the court officer will read later. The chamber will not decide on the guilt or the innocence of Mr. Mokom at this hearing. Rather, pursuant to Article 61, paragraph 7 of the statute, of the Rome Statute, the duty of the chamber is determining whether there exists sufficient evidence to establish substantial grounds to believe that Mr. Mokom has committed the crimes with which he has been charged. If some or all of the charges are confirmed, a trial chamber will subsequently decide on the guilt or innocence of Mr. Mokom at a later stage. I have forgotten to introduce the chamber, which is composed by Judge Akane on my right, Judge Ugalde on my left, and myself, Judge Aitala, presiding judge. The following general principles which apply to the hearing are, in accordance with Article 66 of the Rome Statute, the suspect shall be presumed innocent until proved guilty before the court. Second, the burden of proof rests with the prosecution, which, as a consequence, will have to provide sufficient evidence in order to prove the charges brought against Mr. Mokom to the relevant standards that I've mentioned before, provided in Article 61, paragraph 7 of the statute. Third, the defense will enjoy all rights enshrined in Article 61, 6 and 67 of the statutes. I will recall, and this is especially for the public, that while the general rule is that the hearing is public and therefore is held as now in open session, it might occur that with a view to protecting certain private or confidential information, particularly regarding victims and witnesses, parts of the hearing will be held in private session upon decision of the chamber. Pursuant to the order setting the schedule and directions for confirmation of charges hearing, its filing 244 of 14 July 2023 for the records, we have set aside 20 minutes for further discussions in relation to observations under Rule 111, paragraph 3 of the Rules of Procedure and Evidence, if necessary. The parties and participants will have then 20 minutes each for opening statements and 30 minutes each for final statements. The prosecution is being granted 2 hours to present its arguments on the merits, while the defense is being granted 4 hours to present its arguments on the merits. The common legal representative of victims are granted 2 hours to present their arguments on the merits. I remind everyone, the parties and participants, that oral submissions must be concise and repetitions of any argument set out previously avoided. This is true especially for the prosecution, which has already had the opportunity in writing to present submissions. Final statements may not be used to raise new arguments, but only to respond to arguments and questions raised during the hearing. I draw the attention of everyone to the need to, of course, ensure that your microphone is turned on when you're speaking, and to speak slowly and pause for about 5 seconds before answering any questions and after each sentence, in order to allow the best possible live interpretation and transcription of the hearing by our excellent specialized personnel. The parties and participants shall never interrupt each other and will request the presiding judge to be heard. The parties and participants shall clearly indicate whether their submissions can be presented in public session or whether it is necessary, or they believe that it is necessary, to move into private session. And whenever parties and participants refer to evidence, they must indicate its level of confidentiality and specify whether it can be referred to in public session or it needs to be referred to in a private session. The parties and participants shall clearly indicate when it is no longer necessary to remain in private session, and when in public session, parties and participants shall refrain from mentioning the names of victims and witnesses and refer to their codes or pseudonyms. At the conclusion of the confirmation of charges hearing, the parties and participants shall provide a list with the items of evidence they have referred to during the submissions to the Chamber by way of email. Now, I turn to the reading of the charges. Rule under 22, paragraph 1 of the Rules of Procedure and Evidence provides that the court officer shall read out the charges as presented by the prosecution in an abridged version of the longer document containing the charges. The full version of the document containing the charges is publicly available. I recall for the public that the document containing the charges only brings the allegations of the prosecution. So what will be read now is not what has been decided or what it is, but it's what the prosecution is alleging. The Chamber has the duty to assess whether the evidence presented by the prosecution is sufficient to confirm any of the charges. Now, Mr. Court Officer, I will kindly ask you to read out the document. Thank you very much.
The prosecutor brings 20 charges against Mr. Maxim Geoffroy Eli Mokom Gawaka relating to crimes against humanity and war crimes committed by the anti-Balaka during and in the aftermath of attacks on 2 locations in the Central African Republic. Charges 1 to 8 concern crimes committed in Bangui, the capital city of the Central African Republic, from at least 5 December 2013 until at least the end of April 2014. Charges 9 to 20 concern crimes committed in the city of Bosangoa in the Uham prefecture of the Central African Republic from at least 5 December 2013 until at least the end of April 2014. The crimes charged, which were committed in Bangui from at least 5 December 2013 until at least the end of April 2014, are the following. Count 1, directing attacks against the civilian population as a war crime, punishable under Article 8, Paragraph 2E1, insofar as during the 5 December attack on Bangui and or in its aftermath, the anti-Balaka intentionally directed acts of violence against the Muslim civilian population or individual civilians not taking part in the hostilities. Count 2, attacks against buildings dedicated to religion as a war crime, punishable under Article 8, Paragraph 2E4, and Count 3, destruction of the adversary's property as a war crime, punishable under Article 8, Paragraph 2E12, insofar as during the 5 December attack on Bangui and in its aftermath, the anti-Balaka intentionally dismantled and destroyed numerous mosques, including the mosques in Boying, Gobongo, Fu, Petevo, Kawanga, PK12, Miskin, and Malimaka, which did not constitute legitimate military target. And insofar as the anti-Balaka also intentionally destroyed or damaged houses in predominantly Muslim neighborhoods such as Fu, Miskin, Combatant, Kina, Sara, PK5, Kokoro, Buka, PK12, and PK13. Count 4, pillaging as a war crime, punishable under Article 8, Paragraph 2E5, insofar as during the 5 December attack on Bangui and in its aftermath, the anti-Balaka pillaged Muslim houses and shops including roofs, doors, and windows. Count 5, deportation and forcible transfer as a crime against humanity, punishable under Article 7, Paragraph 1D. And count 6, displacement of the civilian population as a war crime, punishable under Article 8, Paragraph 2E8, insofar as during the 5 December attack and in its aftermath, without grounds permitted under international law, the anti-Balaka forced thousands of Muslim civilians of all ages to leave their homes and communities by expulsion or other coercive acts by the end of April 2014. Count 7, severe deprivation of physical liberty as a crime against humanity, punishable under Article 7, Paragraph 1E, insofar as the anti-Balaka in Bangui prevented Muslim civilians of all ages from leaving the Bangui enclave in the PK5 neighborhood, where the civilians were sheltering, during and in the aftermath of the 5 December attack, enduring a lack of adequate food, shelter, and health care. Count 8, persecution as a crime against humanity on political, ethnic, religious, and national grounds concerning the Muslim population in Bangui and based on the facts underlying counts 1 to 7, punishable under Article 7, Paragraph 1H. The crimes which were committed in Bosangoa from at least 5 December 2013 until at least the end of April 2014 are the following. Count 9, directing attacks against the civilian population as a war crime, punishable under Article 8, Paragraph 2E1, insofar as the anti-Balaka intentionally directed acts of violence against the Muslim civilian population or individual civilians not taking part in the hostilities in Bosangoa during and in the aftermath of the 5 December attack. Count 10, murder as a crime against humanity, punishable under Article 7, Paragraph 1A. And count 11, murder as a war crime, punishable under Article 8, Paragraph 2C1, insofar as in the course of the attack in Bosangoa, the anti-Balaka killed at least 18 Muslim civilians who were taking no active part in the hostilities. Count 12, rape as a crime against humanity, punishable under Article 7, Paragraph 1G. And count 13, rape as a war crime, punishable under Article 8, Paragraph 2E6, insofar as in the course of the attack on Bosangoa on 5 December 2013, anti-Balaka elements raped at least 2 Muslim women. Count 14, attacks against buildings dedicated to religion as a war crime, punishable under Article 8, Paragraph 2E4, and count 15, destruction of the adversary's property as a war crime, punishable under Article 8, Paragraph 2E12. Insofar as during the attack on Bosangoa and or in its aftermath, the anti-Balaka intentionally dismantled and destroyed several mosques, including the central mosque of Bosangoa, which did not constitute a legitimate military target, and insofar as the anti-Balaka also intentionally destroyed or damaged hundreds of the houses in neighborhoods such as Boro, Arabe, and Fulbe that were regarded as predominantly Muslim in character. Count 16, pillaging as a war crime, punishable under Article 8, Paragraph 2E5, insofar as during the attack and in its aftermath, the anti-Balaka pillaged Muslim houses and shops, including roofs, doors, and windows. Count 17, deportation and forcible transfer as a crime against humanity, punishable under Article 7, Paragraph 1D. And count 18, displacement of the civilian population as a war crime, punishable under Article 8, Paragraph 2E8, insofar as, without grounds permitted under international law, the anti-Balaka forced thousands of Muslim civilians of all ages to leave their homes and communities by expulsion or other coercive acts. Count 19, severe deprivation of physical liberty as a crime against humanity, punishable under Article 7, Paragraph 1E, insofar as the anti-Balaka prevented, by threat of death, over 7,000 Muslim civilians, mainly from the neighborhood of Boro, from leaving the compound of the École de la Liberté, where they were sheltering. Count 20, persecution as a crime against humanity on political, ethnic, religious, and national grounds, concerning the Muslim population in Bossangoa and based on the facts underlying counts 9 to 20, punishable under Article 7, Paragraph 1H. Mr. Mokom is criminally responsible for the charged crimes by 1. Aiding, abetting, or otherwise assisting in the commission of these charged crimes by the anti-Balaka, aware that these types of crimes would occur in the ordinary course of events, and while acting with the purpose of facilitating their commission, pursuant to 25 paragraph 3c, and or 2, contributing to the commission of the charged crimes by the anti-Balaka, acting with a common purpose, with the aim of furthering the group's criminal activities and or purpose, aware of its intention to commit such crimes, pursuant to Article 25, Paragraph 3D1 and 2 of the statute. Mr. Mokom contributed to the charged crimes committed by the anti-Balaka in Bossangoa and Bangi by, first, participating in planning the implementation of the common purpose after the 24 March 2013 coup d'etat. Second, participating in the formation, structuring, development, and organization of the anti-Balaka, including the incorporation of pre-existing and new self-defense groups from at least June 2013 until at least April 2014. Third, coordinating the deployment and military operations of the anti-Balaka from at least September 2013 until at least the end of April 2014, including the 5 December 2013 attacks on Bangi and Bossangoa. Fourth, providing the anti-Balaka with logistical support for military operations from at least September 2013 until at least the end of April 2014, including by providing funds, weapons, medication, and ammunition. Fifth, supporting, promoting, and endorsing the crimes of the anti-Balaka against the Muslim civilian population from at least September 2013 until at least the end of April 2014. At the time of his contributions, Mr. Mokom knew that the charged crimes would occur in the ordinary course of events, and of the intention of the anti-Balaka to commit such crimes. Furthermore, in making the contributions described above, Mr. Mokom acted with the purpose of facilitating the commission of crimes such as the charged crimes and the aim of furthering the criminal activities or purpose of the anti-Balaka. Thank you, Mr. President.
Thank you very much, Mr. Court Officer. Now, the parties have not submitted written observations according to Rule 122, paragraph 3 of the Rules of Procedure and Evidence, which refers to issues related to the proper conduct of the proceedings prior to this hearing. Can you confirm you don't have any, or Mr. Rusher, do you have any?
Your Honor, we have not, with your leave, we have not provided any written submissions, but we would like to take a few minutes of this 20 minutes that is allocated for procedural issues to discuss some topics which we think should be brought to the attention of the Chamber.
You're allowed to do it. Please, proceed. Yeah.
And I guess you will not be surprised to hear that what I want to talk about is the exculpatory evidence in this case. As your honors are well aware, we filed last Friday 2 tables containing, for the first one, 275 pages, and for the second one, Annex B, 201 pages. And these pages are filled with exculpatory evidence that was identified by the prosecutor itself, following an order from your honors. And this exculpatory evidence we received in mid-June, 2 months ago. Whereas it's a well-known principle, an established principle, that the prosecutors, before this court, but before other international tribunals, who are handling massive amounts of material, are supposed, A, to know their case before they go to trial, here to go to confirmation hearing, and B, to investigate both à charge and à décharge. We don't take lightly that when Maxime Mokom was arrested in March of 2022, some of the exculpatory evidence that we received in June dates from before his arrest, from 1521, for example. And what we want to point out to the pretrial chamber is that after receiving these hundreds of exculpatory evidence extracts, which concern, your honors, every aspect of the case, every aspect of the OTP theory. Who committed the crimes? Who ordered them? What were the targets? You can see in these tables, all these topics are identified in the table. Mosques with weapons in them. In total, we have received 350 indications in the case file of exculpatory evidence. And these indications refer sometimes to a transcript of 90 pages where you find 15, 20, or 10 different extracts which are deemed exculpatory. 350 new indication in 2 weeks. Assuming the prosecutor worked full-time, that's 25 per day. If a person was working 8 hours per day for 14 days, that would be 3 per hour. And on 14th June, after the last transmission of exculpatory evidence, silence. Nothing. Did they stop doing it? I can confirm to you, and you will see over the course of my submissions, that the case file is replete with more exculpatory material. Replete. You will see also in our tables that there are errors, that we are pointed at extracts or material which mean nothing, which have no exculpatory value at all. We don't blame the prosecutor. We understand that this had to be done in a very short time. We appreciate that. What is the problem? And this is what I want to bring your attention to. Why can't the prosecutor identify in a case file that is managing, investigating for the last 9 years, why isn't he able to identify what suggests the innocence of the accused? Because what is exculpatory material? It's that. evidence that contradicts your theory, evidence that contradicts your thesis, evidence indicating that maybe the crimes were not committed exactly as we suggest, or maybe by other persons. Why can't he do that? I can suggest an answer, but I don't know. I'm not in the mind of the prosecutor. I'm on the receiving end, like you, of that process. What is exculpatory evidence, I just said? Evidence that suggests the innocence of the accused. What do you need to be able to identify that? To identify evidence that suggests the innocence of the accused. You need to have a clear theory. You need to know what suggests his guilt. If you don't know what suggests the guilt of the accused, how will you be able to find what suggests his innocence? And we suggest that this is an indication, this failure, because it is a failure of the prosecutor, to give that material when Mokom was arrested instead of 2 months before he's asking to confirm charges, severe charges against him, stems directly. That problem stems directly from their incapacity to properly identify incriminating material, as we will demonstrate later this week. Beyond this problem of exculpatory evidence, there are other areas which we had a very short time to request disclosure. Your honors are aware, we made some disclosure requests. We obtained some material, but we are still sur notre appétit, sorry for the translator, but we remain on our appetite because we know there is more. For example, the arrest warrant of Mr. Mokom talks about child soldiers. Where are they? Gone. Did they turn 18? What happened to them? Was that fabricated evidence? Who did that? For what purpose? Why did that disappear from our case? Are some of the current witnesses of the prosecution involved in some sort of scheme? We don't know. It's not material because we're not charged with that anymore, but we would like to know because it may have an impact on the rest of the evidence. If I may allow, Your Honor, a brief closed session because I want to be on the safe side. It's going to take 2 minutes, and then I'll finish with that.
Mr. Court Officer, let's go into private session, please.
We're back in open session, Mr. President.
Monsieur Rocha, please
Thank you.
conclude.
Just concluding notes. Why is the prosecutor not forthcoming? Why can the prosecutor identify exculpatory evidence? If this was a case with 10 statements and a very specified and localized allegation, it would not matter much. We would be able to do it ourselves, to find the evidence that is exculpatory and to use it ourselves. But this is a case comprising hundreds of thousands of pages. This is a case encompassing the whole of the Central African Republic. I'm sorry. And the prosecutor is supposed to do that for you, for us, for truth. This is a truth-seeking exercise, as far as I know. And because of those failures, we are running away from it rather than approaching it. And I want you to be aware of that and to read the lines in these tables, which again, I will not be able to refer to them all, but they do undermine every aspect of the prosecutor's theory. I thank you for your attention.
Thank you very much, Mr. Counsel. Mr. Prosecutor, the floor is yours. 10 minutes.
Merci beaucoup, Monsieur le Président.
Thank you very much, Mr. President, Your Honors.
Donc, je passerai la parole à
I will
Madame Léonie
ask Madame
répondre
Leonie
à
to
certains aspects.
answer
Mais avant cela, je voudrais juste
some of the questions raised. But before doing so, I would like to point out to you
alloué
that
cet exercice a
I
été
do not believe that the time
adéquat.
allotted for
Je pense
this
que ce temps n'était pas
exercise has been
aménagé
used
pour faire
properly.
une sorte de plaidoirie
This was not the
par
opportunity
anticipation.
for
Ce
pleadings
temps n'avait pas été
by
aménagé pour
anticipation.
venir nous indiquer
This particular
si le
slot
démarche
wasn't
du
set
procureur
aside
n'est pas la démarche
for
la plus
anyone
claire,
to point out whether the
si
prosecutor's
le document
case
contenant
has
les
been made
charges
clearly
correspond
or
ou
whether
non
the document containing the
aux charges
charges
telles qu'ils étaient déjà dessinées.
corresponds
au
to
niveau
the
du mandat
charges defined
pense que
therein
cet
and in the
espace était un
arrest
espace qui
warrant.
avait été
I think
aménagé
this space, today's hearing, was organized
aussi
by
par rapport à
you
certaines questions spécifiques,
to
qui sont des
address
questions de
some
communication
specific
interne ou d'autres
issues
questions.
relating
Est-ce
to
que il y a eu des
disclosure
difficultés
and
pratiques?
such matters that
Est-ce que
may
ces
be
difficultés, nous
practical,
avons été à la
which
hauteur?
need
Est-ce que vos
to
ordres,
be addressed.
que vous
Were
avez
they
donnés
properly
étaient
addressed?
Est-ce que nous y
Were
avons obéi ou
your
pas?
orders
C'était ça la
obeyed or
différence
not? And I think this
de
is
ce
the
temps
purpose
aménagé.
for which this
Mais ce que nous
particular
avons
slot
entendu,
was
c'est plutôt
set
une sorte de
aside.
critique en règle,
What we have
critique
heard
que-
instead is
pour
a
laquelle il y a
critique
déjà un
of the
temps pour cela.
rules, and
Je
this
voudrais juste
has already been provided for at
expliquer
another
pourquoi
time.
que ce temps
There's
était-
a
qui avait été
space for
aménagé
that to
pour
be
autre
done,
chose,
and so
soit
this
utilisé pour
specific
une plaidoirie par
period
anticipation.
was
Merci
set
beaucoup.
aside for something else,
Madame
not
Mokom,
for
veut ajouter des choses
submission
par
of
rapport aux
our
questions
specific arguments. Now, Madame Leonie would now
Merci, monsieur.
add to what I have just said. Thank you very much, Mr. President.
Mr. Prosecutor, we will rule on the submissions of the defense and your response in due course, but you will have plenty of time to go into the merits later in the hearing. For now, I would encourage then your colleague to focus on this specific matter now, and the DCC, you will have time to do this later on. Please, Madam Prosecutor, proceed.
Thank you, Your Honor, and good morning. I will be very brief in addressing the points raised by the defense just now. Contrary to what was said by Maître La Rochelle, the defense had received the majority of the information from which the prosecution then analyzed whether there is exculpatory information in there or not, way ahead of June. And Your Honors, I'm not going to go into details because there's been plenty of submissions on these issues, but whether by disclosure or migration, the information relevant to the case file of Mr. Mokom was put at the defense's disposal. The analysis of importance for exculpatory evidence was then provided 2 months before this hearing. And the fact that the defense was able to work with this prosecution's analysis, take it into account, categorize it, assess it is evidenced by their filing, which Maître La Rochelle has referenced today already as well. The extensive annexes categorizing the information, taking it in. This shows that the defense was able to review and to process this important information ahead of this hearing. They cannot claim prejudice now in light of that, in my view. One additional point on the prosecution's case theory. You will hear today, again, what that theory is. We will make that abundantly clear. It is set out in the DCC, but you will hear it today and the evidence we rely on. On disclosure, all information relevant to Mr. Mokom's charges has been put at the disposal of the defense. There has been no requests also in recent weeks where the prosecution has not immediately responded, provided what was necessary, only in very limited situations where clearly Rule 77 was not triggered. Otherwise, everything was provided. And this includes on the issues that Maître La Rochelle referred to in the private session just now, which I'm not going to go into here in detail. There's no reason to complain. They have everything on these issues. And with that, I close my submissions. Thank you.
Thank you very much, also for responding briefly. Mr. Rochelle, if I can give you just 2 minutes if you want to counter-reply, just 2 minutes.
Your Honor, the prejudice is not only to us, it's not only to Mr. Mokom, it's to you. You are preparing on the basis of a document, the DCC, which was given to everyone in March. And then, 2 months later, you receive the indication of what evidence undermines that case theory. After, where it was supposed to be provided to us, there was an order. It was supposed to be given all to us in February, not in June. And this is material that they had when you, I'm not going to go there, but when you track this material, it goes back months, years sometimes. So the prejudice is not only to us, it's to the truth. It's to rationality, it's to objectivity. This is the victim. And yes, there is a prejudice, because we have to analyze that, we have to identify the errors, we have to change our preparation, we have to, oh, there's more. And we find more, and you will see that there is still more. So yes, there is a prejudice. The prosecutor does not know its case, and he's trying to send Mr. Mokom to trial. If that's not a prejudice, I don't know what it is.
Thank you very much. Mr. Prosecutor, I would close it here unless you really have to. No. Okay, thank you.
Monsieur le Président. Monsieur le Président.
Mr. President, I would like to take the floor. It's not for a plea, but to inform you of a very serious difficulty that we encountered. Our team was designated as representatives of victims in March, following the decision of your chamber of the 7th of August 2023. Our individual letters of appointment were notified to us on the 11th of August 2023. And from that point on, we should have had access to the materials this was the first thing that should have started. Now, we arrived yesterday. We were told on Friday we will have access, but afterwards we had no access. We went down to that room in the afternoon. We had no access. And to tell you everything, the access to the files, to the
Right now, we're discussing Rule 122, paragraph 3.
Oui.
And this is not...
Alors, j'y arrive.
I'm
Vous comprendrez que,
coming to that. We are simply saying that we are not fully prepared because we were not aware of the difficulties. And as far as we are concerned, we did not have the access to know the substance of that file.
I understand. We'll check this now. Let me...
Mais je voulais vous faire part de cette difficulté.
I simply wanted to share that difficulty with you, no less, no more.
Thank you. We will look into this. Now, on the on Rule 122, we will, of course, rule in due course, pursuant to Rule 122, paragraph 6. Now, we will proceed with the opening statements. I recall that back on 16 August, the Chamber authorized a request submitted by the defense by email for Mr. Mokom to make an unsworn statement as part of the defense opening statements. Floor to the prosecution then.
Your Honors, we will need access to evidence too to broadcast the presentation, if that's possible. Thank you.
Monsieur le Président, Madame et Monsieur
The
les juges,
Deputy Prosecutor, Mr. President,
le premier substitut
Your Honors,
Van Brown vous présentera les faits
Senior Trial Lawyer
relatifs aux charges
Van
que le
Brown
bureau du
will
procureur
present to
a
you the facts
contre
and, if necessary, the charges against Maxime Gawaka. In this opening statement, I will focus on presenting to you the general context within which the crimes were committed, crimes in which Mr. Mokom took part. Had it not been the requirements of the procedure, I would have said that this presentation is superfluous because it is already known, that general context is already known to this jurisdiction. And the truth is that it is only because of a late arrest that we have this hearing. Mr. Mokom should actually have been tried at the same time with Ngaisona and Yekatom. There was a single document containing the charges against the three, but because of the gaps in the arrests, it was necessary for us to separate the cases. But these facts remain facts relating to blood. Now, there's still the principle of relativity. It supposes that each
d'un
case
regard neuf
that
des juges,
is considered separately
comme si les juges voyaient pour la
should be
première fois son
considered
dossier.
by the
Mais vous
judge
savez aussi que
as
ce
if
principe n'a
they
rien
were
d'absolu.
seeing
Il l'est d'autant moins
the
que la
case for the
confirmation
first
des
time.
charges ne postule pas à un prononcé sur la
The
culpabilité.
confirmation of charges
généralement
also
sur des
does
preuves
not
parfois
decide
non
on
contestées par le
guilt
contre-interrogatoire.
and also
L'économie
the
judiciaire et la nécessité
evidence
d'éviter la contrariété des
may
jugements
not be
milite
contested.
souvent en faveur d'une reprise à leur compte par les juges.
This,
constatations
the
déjà
judges
établies dans des décisions
usually takes into
Pour autant que ces
account
constatations ne portent pas
judicial
atteinte
notices
à la
that are
présomption
already taken
d'innocence.
before, but this does not undermine the presumption of innocence. The domain of judicial notices is very vast, and I call on the judges to explore them.
de vous soumettre les
But
éléments à
throughout
charge
our
résumés dans nos
presentation,
conclusions écrites.
we will
Ces éléments
present to you
établissent des motifs substantiels
our written conclusions, and they include substantial grounds to support the criminal activities
contribué aux
charged
attaques
against
anti-Balaka
Mr. Mokom. Mr. Mokom contributed in the anti-Balaka attacks against Bangui and Bosangwa,
subséquents.
as well as the subsequent attacks.
A agi
Mr. Mokom
avec l'intention et la
acted
reconnaissance
with the requisite
selon le statut.
knowledge and intent required by the statute. The crimes charged against Mr. Mokom were committed in Bangui, the capital, and in the region of Bosangwa, which is 300 kilometers north of Bangui. The Central African Republic had about 6 million inhabitants. It was multi-ethnic and multi-religious. Before the conflict, there were about 50% of Christians, 35% Muslims, and the others were practicing traditional religions. François Bozizé was the president of Seleka in 2012, and it was in August of the same year that the Seleka coalition emerged from the northeast of the country. It was an alliance of several armed groups, which was mainly made up of Central African Muslims as well as Chadian and Sudanese mercenaries. As from December 2012, the actions of Seleka intensified and they progressed towards Bangui. Bangui fell in March, and President Bozizé fled the country. The head of the Seleka, Mr. Jotodia, became president, having taken control of the state. Seleka submitted the non-Muslim civilians, for the most part, to unspeakable atrocities, and these brutalities sowed the seeds of vengeance which motivated the anti-Balaka. When, after the coup d'etat of the 24th of March, Bozizé and his associate fled to Cameroon, Mr. Mokom fled to Zongo, which is a border town a few kilometers from the Ubangi River. The anti-Balaka were made up of former members of the Presidential Guard of Bozizé and the Central African Armed Forces, known as FACA, as well as other existing members. What brought them together was the hatred against Seleka and anyone considered as their associates, including the Muslims. The anti-Balaka were organized and coordinated by groups located in three main areas: in the Central African Republic, in Cameroon, and in the DRC. In the Cameroon group, there was Bozize and other personalities, including Patrice Ngaisona and Bernard Mokom, the father of Maxime Mokom. The group of the DRC had the supporters of Bozize who had fled to Zongo after the coup d'etat, as well as the supporters, as well as Mr. Mokom, who became the coordinator of anti-Balaka operations. From Zongo, Mr. Mokom supported the anti-Balaka, and this was as early as mid-2013. He was the one who looked for ammunition, coordinated the deployment of anti-Balaka in the prefectures, and oversaw their attacks. Mr. Mokom was in communication with senior figures of the inner circle of Bozize in Cameroon. He was in regular contact with the zone commanders in Bangui and in the prefectures. In the Central African Republic, the groups operated in Gobere, Bangui, and Kalongoy. In September 2013, the anti-Balakas started implementing their strategy to take over power. Before the major attacks of the 5th of December 2013 in Bangui and Bosangwa, within the context of which the crimes have been charged, the anti-Balaka attacked several towns and villages. The crimes committed during those attacks, you will realize, do not form part of the charges in this case, but we know that it is important to refer to them to prove the fact that the anti-Balaka were following a modus operandi which was already in place. These attacks were carried out in Bosangwa, in Boa, in September 2013, and the anti-Balaka killed hundreds of Muslim civilians in schools. They burned down hundreds of houses and pillaged their cattle. These attacks led to the enforced displacement of Muslims, many Muslims, to the regional capital of Bosangwa. In October, in Yaloke and Gaga, the anti-Balaka, after having attacked Seleka, turned to attack the Muslim civilians. Many of them died in their houses and mosques were destroyed. In November 2013, the anti-Balaka attacked the pearl camps in Boali, which is between Bosangwa and Bangui, killing dozens of people. Between the months of October and November 2013, the anti-Balaka attacks and confrontations with Seleka were reported in other locations such as Boa, Bosembela, and towards the end of October in Beloko and November of the same year. Other villages were attacked later on. Bohong, for example, on the 12th of December, where 27 persons, most of them Muslims, were killed by the anti-Balaka. The crimes committed against the Muslims during the period from September to December were mainly reported by both the local and international press. A report of France 24 of the 16th of September 2013 shows a Muslim village which was reduced to ashes.
Deux femmes sortent de la brousse. Elles nous montrent un premier corps. puis un second.
Two
Au total,
women come
6
out of
victimes
the
assassinées à coups de
bush
machette.
and they show
Jamais de ma
us
vie. Jamais
some
vécu ça.
bodies.
À la nuit tombée, des dizaines de villageois accourent,
At
des femmes et des
nightfall,
enfants affolés.
dozens of villagers were running away, women and
Les soldats de la
children.
force d'interposition persuadent les habitants de trouver refuge en ville.
The soldiers of the peacekeeping force appealed to the inhabitants to go to
Ces
town.
survivants laissent derrière eux
The
des dizaines d'enfants
survivors
toujours terrés dans la boue.
left terrorized children in the
Dans un
bushes.
reportage sur Bossangoa, au
In
mois de
that
septembre,
report in Bosangwa in September
Al Jazeera
2013,
la parole à un civil
Al Jazeera gave the floor to a Muslim civilian who fled his village after the Anti-Balaka had killed his
Salaka was
father.
attacked by a group called Anti-Balaka, which means anti-machete in the local language. On the other side of town, Muslims are hiding in a school. They accuse men from Anti-Balaka of targeting them. Muhammad Idris says they killed his father. He's now looking after his family of 20.
My message to these people is they may want to retake power, they may want to get back in government, but they need to spare civilian lives.
À Boali, vers le 2 décembre 2013,
In Bwali, around December 2013, the Anti-Balaka, armed with machetes, knives, and guns, attacked a Pearl camp. They killed at least 12 persons and wounded several others. Many children were amongst those victims. These victims were transported to the Bangui hospital. Our resources are limited. There were people who were struck by machetes on the skull. We don't know what will happen to them. In 2011, the population of Bangui was 740,000, including 130,000 Muslims in the 8 arrondissements of the town. The demographic composition of the town changed radically after the Anti-Balaka attack of the 5th of December 2013. Mr. Mokom contributed to the Anti-Balaka attack against the Muslims against Bangui by encouraging and arming the Anti-Balaka from Zongo. On the same day, on the 5th of December 2013, a few hours later, the Anti-Balaka also attacked Bosangwa. Once more, they targeted Muslim civilians and did not discriminate against these people and the Seleka. The bodies of those who were killed were taken to the Ali Babolo Mosque in PK5, and this place became infamous because the civilians went to look for their dead relatives there. You will see an image on the screen dated 5 December 2013, and this is an image of several bodies on the grounds of the mosque. The climate of violence following the 5th of December compelled Jotodia to resign on the 10th of January 2014 under international pressure. On the 20th of January, the mayor of Bangui, Catherine Samba Panza, was elected interim president. In the same month, the Anti-Balaka adopted a formal structure, and once again, Mr. Mokom was appointed a coordinator of operations. On the 6th of February 2014, Mr. Mokom crossed the Ubangi River and based himself in Bangui. However, the resignation of Jotodia did not put an end to the anti-Balaka attacks. The partial disarmament of the Seleka and the retreat of the forces from Bangui, as well as from other parts of the west of the Ka, created a vacuum of power and left the Muslim population vulnerable to the vengeance of the anti-Balaka. So the frequency and scale of the crimes increased. On the 22nd of January 2014, the anti-Balaka began attacks against the Muslim community of Yaloke. They killed and wounded Muslim civilians, and a young girl was raped and killed. They burned and pillaged houses and Muslim shops. Confined under the threat of the anti-Balaka, the members of the Muslim community endured deplorable conditions during the year 2014. The anti-Balaka attacked Bosem Tele during that same period. Once more, they killed several Muslim civilians. They pillaged and burned several houses belonging to Muslims, as well as their shops and mosques. Muslim civilians fled en masse and took refuge in the Catholic mission of the town. In July 2014 or later, almost the entire population, Muslim population of the town, had been evacuated.
You have 1.5 minutes left.
Yes, and I will. That will suffice.
This is an excerpt of a video which shows Muslims enclaved in Boda in April 2014, as well as an anti-Balaka chief in Boda talking about the surrounding of the enclaved Muslims.
Children in this war-torn country are going hungry. Bloodshed and repeated attacks have left all Muslims huddling in one district of a former diamond town. They're learning to live without.
Everything is blocked. Nothing comes in. It's very expensive to buy food. Our life is at a critical stage. It means like we live in a prison. We don't have freedom. It's not freedom, or it's a freedom under surveillance. We don't understand it.
They are encircled by the anti-Balaka, a Christian militia that vows to kill Muslims that step outside the perimeter.
We can wait for 10 years for them to leave. We cannot accept living together with Muslims long term.
Voilà. Donc,
Around February 2014, Mr. Mokom addressed himself to the anti-Balaka zone commanders, and he explained to them that the battles will end only after power had been taken over and Bozize had returned to Bangui. So it is at this point, Mr. President, Your Honors, that I conclude my opening statement, and I thank you very much for your kind attention.
Thank you very much, Mr. Prosecutor, for your opening statements. Now, I give the floor to the Common Legal Representative of Victims for the opening statements. You are allowed 20 minutes.
Je vous remercie, Monsieur le Juge.
Thank you, Your Honors. Thank you, Your Honors. I rise today on behalf of the legal representatives of victims, and I would like, first of all, to recall that pursuant to the preamble of the Rome Statute, the creation of the International Criminal Court, a permanent and independent court, is the result of findings by state parties, whereby during the 20th century, millions of children and women were victims of atrocities that defy human imagination and conscience. They were of the view that such crimes should not go unpunished and that there is need to stop and check them by contributing to the commission of new crimes. This is like dealing with a lie that runs faster than the truth, but at the end of it all, the truth always prevails. What has happened is that crimes continue to run very fast, but as I have said, justice will overcome, and at the end of it all, play a dissuasive role. In any event, let us recall that the International Criminal Court only has a complementary role to play regarding national jurisdictions when they don't have the capability or the will to address crimes that fall under the jurisdiction of the court and which appear to have been committed on their territory. Such is the case before us, whereby the Central African state referred this case to the court. For at least 2 decades, the Central African Republic has been subjugated to crimes, and the perpetrators of which have remained unaccountable, thereby creating a culture of impunity and violence as a method for the settlement of scores, and therefore making way as well to the propensity for amnesties and paving the way for so-called peace agreements between politicians which take place outside of or regardless of the victims. In 2013, during the transition in the CAR, there was an awakening of consciousness relating to justice during the consultations with the people at the base, which culminated in the National Forum, which came up with strong recommendations to banish impunity and to reject amnesty. In short, the people of the Central African Republic call for justice to be meted out against all perpetrators of violence without any distinction. Mr. President, Your Honors, Maxime Mokom is one of those who took up arms to get to power at any cost while creating terror within the population, the civilian population who do not participate in their activities and also use them as human shields in a view to achieve their ends. In fact, rebellion has become a business in the Central African Republic, whereby anything can be done and all claims can be made. When the arrest warrant was issued against Maxime Mokom, the judges of the pre-trial chamber were of the view that there is reasonable grounds to believe that Mr. Mokom committed the crimes charged against him. Today, you must come to the determination whether there is sufficient evidence and substantial grounds to believe that Maxime Mokom indeed committed the crimes charged against him and thereby defer him to trial. We recall that in the document containing the charges, the prosecutor accuses Mr. Mokom of being the perpetrator on the Central African Republic territory of crimes against humanity and war crimes, including pillaging, persecution, murder, rape. And these are the crimes to which have been extensively described by the victims whom we represent. The Mokom case flows from the recent 2013-2014 conflict between armed groups in the Central African Republic, namely the Seleka Coalition and the Anti-Balaka militia. In fact, the Seleka rebels, who were mostly Muslims, took power by force on the 24th of March 2013 after having committed serious crimes before, during, and after the 24th of March 2013 against the population, mostly the civilian population. They wanted to fight and take power back from the overthrown regime, and in so doing, around September 2013, they organized groups known as Anti-Balaka. And Balaka, Mr. President, means machete in Sango, which is the national language of the Central African Republic. Initially, these were self-defense groups made up of local inhabitants who fought with traditional weapons against highway robbers who were causing havoc across the country with their machetes. And that is how they took on the name Anti-Machete. They were brave and were recruited by Mokom, and others were recruited to join them in order to fulfill their purpose. There was brainwashing, and they were incited to commit atrocities on the civilian population, which are tantamount to war crimes and crimes against humanity, as described in the document containing the charges. These elements were armed. They had machetes and firearms. The elements of these groups attacked indiscriminately persons whom they had been brought about to hate and who were deemed to be responsible without any evidence for the crimes committed by Seleka. The Anti-Balaka were organized into subgroups, and each subgroup had a commander. Maxime Mokom was officially the operations coordinator, and this implied that there was a structure and an organization and funding and provision of weapons in the troops. This was common knowledge. I am not going to go back to Mr. Mokom's personal criminal responsibility, which has been properly outlined by the prosecutor in the document containing the charges. Allow me to insist on the harm that Maxime Mokom inflicted on his fellow countrymen, both individually and through his groups, which he masterminded. I wanted to point out to the judges, furthermore, that there is another story that should be told, the story of the victims who are at the very heart of this trial. When it comes to the attacks, these attacks were intentionally targeted at civilians based on various circumstances and for unjustifiable reasons. Let me take a few examples. Victim A 71100/22 declared that they were attacked, she and her sister, by the anti-Balaka under the pretext that they allegedly had betrayed them to the Muslims simply because her sister was married to a Muslim. Victim A 70966/2 narrates that she and her father were attacked by the anti-Balaka, Mokom's anti-Balaka, because her father was a Muslim and because she was her father's daughter. Victim A 71101/22 declared that in her sector, the anti-Balaka attacked all the men, and that is why he was shot at and abandoned. This is further confirmed, or this assertion is further confirmed by victim A 71101/22. Victim 70967/22 affirms that Mokom and his elements attacked them because they suspected that they were guarding the businesses of the Seleka. Maxime Mokom's involvement. Maxime Mokom, in addition to his role, organized the attacks by the anti-Balaka. He monitored the operations and facilitated the activities of the anti-Balaka leaders. And in addition to that, he himself personally participated in the perpetration of the crimes as described by the victims, particularly rapes. Most of the victims, women, were raped, and the purpose of rape was to punish, to destabilize, and to terrorize the enemy. That is how victims A 71100/22, A 70967/22, A 70966/22, A 70970/22, as well as several others, declared that they had been raped by Mr. Mokom Maxime before he invited his elements to do the same thing to them. Mokom's elements openly declare their allegiance to him, and their modus operandi were well known. The idea was to take the victims from Bangui to their base in the Yamrawa school and torture them and or kill them. When it comes to Bosangwa, the town of Bosangwa, it was at the École Liberté that the victims' situation was completely settled. And it is exactly at that spot that the victims had sought refuge. As for Bangui, a number of victims narrated in their statements that in addition to rape, they had been robbed of all their belongings after having been persecuted. Mr. President, Your Honors, all the charges against the anti-Balaka have been established, and the victims whom I have met before coming here ask you, Your Honors, to recognize them as victims. They cannot bear this any further, and they rely on the ICC to give them relief, because when you take all the crises and the conflicts that have unfolded in the Central African Republic, they have not seen any of the perpetrators of these crimes and members of these armed groups being tried. That is why the Special Criminal Court and international organizations have brought some pressure to bear on some perpetrators and even proceeded to try some cases. But when it comes to the ICC, Your Honors, your role is to try the main leaders of these armed groups in order to render justice to the victims who expect that their views and their concerns will be heard. Thank you very much.
Thank you very much, Madam Common Legal Representative of Victims. Now, before we conclude, Mr. Prosecutor, you have not mentioned the ERN numbers of videos you have shown. If you're able to do it right away, otherwise the beginning of next session. You able to do it now? For the transcripts and the records.
We have them on the slides, so if it's okay, I would have to pull up the presentation one more time to read them. I can do that now or after.
We'll do this at the beginning of next session, so you'll be prepared to say the numbers for the records.
Yeah,
okay, thank you very much. Now, we will then adjourn the hearing for a 30-minute break, and we will resume at 11:30. Thank you very much.
All rise. We will be.